Someone started it.
Started the
I
ball.
think it was there.
Good afternoon. Can everyone hear me? I see some nods, so sounds good. Good afternoon, everyone. Let's see, we've got 12:33 right now. Just going to give it another 5 more minutes to see if we get any more board members to come in. Appreciate your patience. Thank you. Well, it looks like we have at least four board members in attendance. We still do not have our chair present, so that leads Mr. Robert Valencia, our vice chair, to run the meeting. Mr. Valencia, I understand the circumstances are not ideal, seeing as this is your first meeting, but we will help you along the way. If you want to go ahead and call to order for roll call for the study session, and we will get going with that.
Hi, Mark. Just a little assistance on starting that process of roll call, please. Hey, Mark, can you hear me?
Yes, I can hear you.
Thank you.
Ms. Hamblin, you want to call roll call for the study session?
I will. Bruce Dawson, not here. Robert Valencia,
Here.
Michael Marks, Irma Duran, absent. Denise Bowles, absent. Michael Schaff,
Here.
Araceli Juarez, here. I think Irma might have just joined our meeting, so Irma Duran.
Here.
Thank you. Mr. Chair, we have a quorum. And you can hand the time over to Mark to run through the study session items.
Thank you.
Okay, just give me 1 second here. I'm going to pull up the agenda for today. Share my screen here. Okay, welcome everybody to the Board of Adjustment Study Session. Today is April 29, 2026. And before we go ahead and get into the case discussions for today, I would like to take this opportunity to do an introduction to our new zoning administrator. And I will go ahead and hand this off to our zoning administrator who will be transitioning out of this position, Elisa Hamblin.
Thank you, Mark. So my position with Planning and Development Services has changed, and so we ran a recruitment for a new zoning administrator. We're very lucky to have Chris join our team. He's taking over that role. This is his first Board of Adjustment meeting and his second week in the office with the City of Tucson. So Chris, do you want to give an introduction to the board about your background, please?
Sure. Thank you very much, first of all, for having me. Excited to join the team. I am Chris Poirier, grew up in Tucson. Immediately after college, joined Pima County Development Services. Worked quite a bit with their Board of Adjustment as well. Spent a lot of years in planning and zoning at the county and was fortunate enough to retire and then join the City of Tucson. So very excited to be here. Very much enjoy current planning and especially the Boards of Adjustment, a critical part of an entire zoning. So thank you so much.
Thank you, Chris. Okay, with that, we'll go ahead and continue on with the agenda. So the next item we have is in regards to cases coming up for May. At this time, we have not received any applications, so there will be no Board of Adjustment hearing for May 27th. Okay, and item number 3 on the agenda, we have 3 cases scheduled for today. And I will go ahead and start with the first one, which is C10-26-02, Enclaves at Tumamoc. That's lots 1 through 129, KB Homes, Tucson. And the location 1802 West St. Mary's Road, R1 and O3 zoning. Okay, so essentially this is the location of the KB Homes lot. It is located on St. Mary's, where it intersects with Anklam in this triangle piece here. So this is a 129 development. The owners used what we call a flexible lot development option in order to get the density that they need for the residences and for the development. In 2019, there was a similar project in Midtown near Fort Lowell and First Avenue called Mountain Enclaves. Very similar development. They also utilize the flexible lot development option. That's a tool that is permitted in the Unified Development Code. What's before the board today is in regards to a zoning administrator's determination that was made for this project on Tumamoc. In January 22 of this year, the zoning administrator issued a determination that was requested by the appellant in regards to how the general plan and area plans are treated when they are applied to these flexible lot developments. So the zoning administrator, in her determination, determined that the general plan and area plan policies should not be treated as binding zoning rules for FLDs, and that under Arizona law, the general plan and area or neighborhood plans are not zoning laws. And finally, that the Tucson Unified Development Code is the city's enforceable land use law that provides the FLDs flexibility as it applies to the UDC dimensional and design standards. The appellant is contending that determination, stating that the policy guidelines and shall statements within the general plan and area plans are mandatory and enforceable as part of the zoning code. So today we have received a total of 15 written comments in support of the appeal. 2 of those comments are outside what we call the notice area. And then we have a total of 9 written comments objecting the appeal. All those comments that were submitted are outside of the notice area. That's pretty much a brief summary for this case. I'll go ahead and open it up to the board for any questions that they have or any clarification needed.
Yeah, I do have a question or two. So the assertion by the party that's filed the appeal is that the compliance with the comprehensive plan or general plan is noted in the flexible lot development ordinance, and therefore compliance with that, with the area plan policies, need to be addressed or demonstrated to be in compliance with in the FLP review process. As I understand it, staff has indicated that compliance with the comprehensive plan or general plan is not required as it is mere guidance and policy as opposed to regulation. And I understand that back and forth and that conclusion of staffs is based upon, or at least in part, on a similar project that you had made reference to. I want to ask a question that sort of goes about this in a kind of another way. Because when I look at the flexible lot development ordinance, the first part of it is the purpose, and it says the purpose of the flexible lot development is to provide greater flexibility and creativity in the design of residential development by, and then there are 10 items or goals or policies listed. Number 2 is implementing the goals and objectives of the general plan, area plan, and neighborhood plans. So my question is, do you read that as every flexible lot development proposed project has to adhere to all 10 policies? Or do they have to demonstrate compliance with one or more of those policies?
Mr. Marks, there's a couple references in the FLD section regarding general plans and neighborhood plans. So the one that you've referenced is in the purpose section. The purpose section is not regulatory. It just describes the intent of the regulations that follow in that section. There is another reference to neighborhood plans, but in this particular instance, anything in the purpose statement, I would use as an understanding of the intent of the regulations that are then found in the section overall. It is not a rule to which we would review against if it's in the purpose statement.
Mm-hmm. So let me ask this. If, and the property in question was developed under existing then and still now existing zoning and not subject to a rezoning, is that correct?
Yes, that's correct. They've opted in to use the flexible lot development option with the existing zoning that is in place.
So if there was a need for a rezoning, might it be possible that conditions would have been added to the rezoning approval that would have ensured that compliance with any specific applicable area plan policies be adhered to?
That is a possibility. When a rezoning is considered, the mayor and council will typically add some conditions. I can't suppose what they might have been in this case, but that is an option, yes.
But given that there wasn't a rezoning and we're dealing with existing zoning, the area plan policies do not come into place. Is that the position?
Our position in the determination is that they are not regulatory because Arizona state statutes pretty much set up the framework of the differentiation between zoning code and guiding documents like general plans and area and neighborhood plans. And so we have to review against the regulations that are actually the hard and fast rules in the zoning code.
Okay. Could you tell me about the flexible land use or flexible lot development process? Is there a neighborhood meeting requirement?
There's 2 steps in which a neighborhood might receive information about the FLD. The first is prior to submittal of an actual application, a notice will go out and a meeting will be held where they can receive information about the project and provide feedback. And then the second point is once an application is formally submitted to the city, a notice is sent out to the surrounding area to notify them of the application being received, but it is not a comment period notice at that time.
So there isn't any neighborhood meeting?
There is a neighborhood meeting before the
There
application.
isn't? Oh, okay, okay.
Before it's submitted, and it's an opportunity for the developer to provide information about the proposed development and hear any comments from the neighborhood.
Okay, and I've read the material, or a lot of the material. And the party filing the appeal alleges that there is inconsistency between the area plan policies, as she asserts, and the project. But I don't recall reading any specific policies that the project is allegedly in conflict with. Are you aware of any such specific policies that the project does not comply with?
Mr. Marks, the subject of the determination was more broad in that compliance is required. It was not a question of whether the project complies with specific policies or not.
Hmm.
So I can't speak definitively as to all of the policies in a neighborhood plan, because again, we use them as broad guidance when we are looking at the FLD, but looking to the UDC regulations as the definitive items we must review against. So there may be specific items that the appellant may feel do not comply from the neighborhood plan and the development, but that is not the subject of the determination. Because the question asked in the determination was whether a area and neighborhood plan essentially must be used as the regulatory framework for review of the development or not.
Okay. And then the process involves the review by staff and then the final approval by the planning director. Would that signify compliance, or would that indicate compliance with all the regulations in the flexible lot development ordinance?
Yes, so when a development like this is proposed, it goes through the city review process and it is reviewed by multiple departments, outside agencies as needed, and they give their approval. Once that approval is attained, then it is a PDSD director decision to issue the permit. And so that issuance signifies compliance with the regulations of the city.
Okay. I think that's all I've got right now. Thank you very much.
Thank you.
I have a question. Was the plan that was presented at the meeting for the FLD prior to the application, did that plan match what was ultimately approved?
Ms. Juarez, I honestly cannot speak to that specifically. I don't have recollection of that item. Generally, I will say applicants will provide a very similar design to what comes in for the application, but that's something that you can clarify with the property owner during the item if you'd like to ask that question at that time.
Thank you.
I have a question. I am wondering about the possible precedent set by us upholding this appeal. If we uphold this appeal, does it make all of the neighborhood area plans in Tucson suddenly enforceable by law?
Chairperson, Mr. Schaaf, what it comes down to is the precedent was set on this not by you, but by the Superior Court of the State of Arizona in that last, the case that was mentioned, I think it was from 2018, 2019. That sets the precedent for how this works. And that's the case that determined that local area plans and general plans are not regulatory, although they may contain a lot of language that people believe is regulatory.
Another question regarding the site specifically. I looked at some old planning development plans in Pima County for that particular site. So I looked up book 8, page 39, showing a medical office what looked at the time to be a nursing home and what appears to be high density residential around that building on that exact site. And at the time, it was shown to be zoned R2 and R4. And I saw permits for the zoning of R2 and R4. And this plan predates the neighborhood area plan by about 10 years. So is there some way that the neighborhood area plan could retroactively change the zoning of a lot?
The zoning, excuse me, sorry, Mr. Schaff. The zoning that you're referencing sounds to me like county zoning that predates annexation into the city. So that would not set any precedent into documents or plans necessarily that are city adopted plans. There was a medical office building kind of located in the donut hole, if you will, or the peninsula of this project that was demolished as part of the redevelopment. So that did exist there for a number of years. There was never any residential development. So when a property is annexed into the city of Tucson, we translate the zoning, which is essentially we compare our zoning and find the next most relevant zone to translate it into the city from the county. So the current zoning of R1 and O3 in the city would be corollary to whatever was in the county.
Okay, thank you for that.
I do want to note for the record that we have Bruce Dawson who has joined us in the meeting. So we now have six board members in attendance.
Do we have any additional questions regarding this case? Okay, I will go ahead and move on to our second case here. So our next case that we have
Hi,
today.
I'm joining from Microsoft Teams. I'm a member of this neighborhood, and is there going to be a time when we can make a presentation from the public?
Yes,
make
there will
public
be a
comment?
time.
Okay, thank
That's
you.
correct. The public hearing hasn't started yet, so but there will be an
Understood.
opportunity.
Thank
Okay,
you.
you're welcome. Okay, so the second case we have for today is going to be C1026-03 La Inedita Restaurant Dining Patio, Liberty Federal Fund LC, located at 722 North Stone Avenue, C3 zoning. So this location is just south of University Boulevard off of Stone Avenue, as you can see in the rectangle highlighted here. The applicant constructed an outdoor patio without prior zoning approval. So now they are seeking zoning approval to allow this outdoor patio to remain. The applicants are here before the board because this expansion actually triggered some code requirements that the applicant now needs to request variances from. So here's a close-up view of the site plan in relation to the area plan here. You can see the dining patio indicated up in the top left corner, and where it is in relation to the aerial. So this is the location of where the patio was added. The variances that they're going to be requesting are to reduce motor vehicle parking spaces from 54 to 14 spaces. to delete the electrical vehicle supply equipment requirement to provide 3 EV installed spaces and 6 EV capable spaces. And 3, to allow an alternative pedestrian circulation path in lieu of a concrete walkway and additional access gate connecting the restaurant to Eccles Avenue right-of-way, which is towards the alley. And number 4, to allow the existing trash dumpster to remain with a new enclosure. So as you can see, this site is existing. It was developed prior to the applicant taking ownership. Just a simple patio addition has triggered code compliance, current code compliance with the UDC. The variances that are being requested are reasonable just because how the site is existing. There's really no just because of the way it's developed, there's really no other space for more parking or for them to provide the required EV spaces to be installed. Also regarding circulation, pedestrian circulation, that's also kind of reasonable not to have that concrete walkway, instead to have a pathway in lieu of that. And the existing trash dumpster, how it is serviced, how it is currently serviced is acceptable. They will be providing the new enclosure with the option of just having it in the same location with the same access point to the trash enclosure. To date, we have received a total of, we have 1 written approval and 0 protest on this one. And I'll go ahead and open it up to the board for any questions.
I have one question. I was looking at the site plan that they provided, and I can't read it off my little print here because it's not large enough, but it looked to me like the dimensions aren't working correctly. I'm getting about 68 feet that they need for all of these improvements. And if I remember correctly, they only had about 66.5 feet. Is the 26-foot aisle a requirement by the city, or is that something that could be adjusted?
Mr.
I'm-
Chair, Ms. Juarez, the precise dimensions that are shown on the plan for the Board of Adjustment can be corrected through the plan review process. The only thing that we would want to make absolutely sure on is any items they're actually granting a variance for, that those items are accurate. To your question as to whether the size of the drive aisle can be adjusted, it can. The minimum is 24 feet. And there are opportunities to reduce that slightly due to site constraints through an administrative review as well.
Do we have any other questions?
Yeah, I do not.
No.
Okay, I'm going to move on to the next case. So the final case we have today is C10-26-04, Frausto Garage Edition, Martin Frausto at 7682 East Apple Tree Drive, Zone R2. So this is the location of the property. It's actually on the east side of town, off near Irvington. And this site, as you can see, this is actually on the south side of East Apple Tree Drive. I'm going to go ahead and go to the next. And we kind of have this flipped around, so try not to confuse anyone here, but just pay attention to the north arrow here. So this is the site plan in relation to the aerial. With the property owner, constructed a garage attached to the, what is the, east side of the residence. And the garage, is right up against the property line. It's a tall garage, with a tall ceiling height, and the variance being requested today is to allow the garage to remain with a 0 setback to that east property line. As you can see with the site, it is pretty developed well without any room for additions to the side yards. So this garage being so close to the property line, or actually at the property line, is a slight constraint. In the neighborhood, there's actually been noted by staff that there are additional properties that have similar site constraints with structures not meeting setbacks. Staff does not have any objection to this variance request. To date, we have received no comments regarding this variance request, and I will go ahead and open up to any questions at this time.
I have a question.
Yes.
I visited the site and I saw that the garage is essentially built on the wall dividing the properties on the property line itself. My main concern would be, is that wall structurally sound to support a garage? Has there been anyone look into that as far as the engineering behind the partition walls?
So as part of the review process, yes, it will go under extensive review, and that includes residential reviews for compliance with building code requirements. So this wall would have been reviewed. Not sure what the comments, if there were any comments regarding it, but I do know that it does have to act as a firewall with the fire barrier between the property lines. So it does need to meet that requirement, which I'm sure the building code does review for that.
Yeah, this is Mike Marks. I just want to add, or relative to the last comment, the project, if we were to approve, will still have to go through building code review. So even if we approve, if that wall is not sufficient, if it doesn't meet fire code requirements, that building can't stand unless there's modifications to the firewall code conditions. Is that correct?
That is correct.
Okay.
One of the questions I had was that when I looked at the wall relative to the new structure, to me, typically the walls will straddle the property line, but this structure is abutted on the neighbor's side of the wall. Will a survey be required from a registered land surveyor that certifies that that structure is in fact completely on this owner's property?
So as part of the permit issuance and reviews, so staff is only reviewing for what's been provided by the applicant. Actual inspections that are done in the field will confirm where the structure lies in relation to property line. So if they are over it, they would either have to correct it, make modifications to the plans, or actually modify the structure to be in compliance with what was approved.
This is Bruce Dawson. So no permit was taken out for this structure in the first place, was there?
That is correct. This was constructed during the COVID period.
Okay, so the likelihood of it meeting code is fairly slim.
It's possible. I do not know where they are at with the building code review.
Okay, so the building code review will have to take place if we approve this thing.
Correct. We're only looking for the zoning aspect, which is the setback to the east, which is essentially eliminated.
So if that's all we think, what forces a code review of this structure?
So in order for the permit to be issued, to get this in compliance, they need approvals from zoning and building.
Okay, thank you.
You're welcome. Are there any other questions? None? Mr. Chair, I think we can go ahead and adjourn the study session and take a break and then come back at 1:30.
Okay, we are adjourned in the study session.
Thank you. Mr. Chair, I have 1:30. If you want to call to order and start with roll call.
Mark, can you repeat that, please?
Sure, I have 1:30 right now. If we want to get to call to order and start the roll call.
Mrs. Hamblin, may we have the roll call, please?
Bruce Dawson,
Here.
Robert Valencia,
Here.
Michael Marks, Irma Duran,
Here.
Denise Bowles.
Bowles, present.
Sorry about that. Thank you. Michael Schaff,
Present.
Araceli Juarez.
Present.
Mr. Chair, we have a quorum.
Thank you. Ladies and gentlemen, welcome to the regular meeting of the City of Tucson's Board of Adjustments. This meeting is being recorded. By joining, you are giving consent for this meeting to be recorded. An introduction of each case will be made by staff. At the conclusion of staff's presentation, the applicant and the applicant's representative will have an opportunity to speak. For the record, please tell the board your name and address and state your request. At the conclusion of the applicant's presentation, other persons wishing to speak in favor of the request may come forward and state their support. When called on by the board, those wishing to speak in opposition to the applicant's request may come forward and state their protest. The chair may allow applicant the opportunity for a brief rebuttal. The chair will then close the public hearing and open up a discussion by the board members. At the conclusion of the board's discussion, a motion will be made and if seconded, will be voted upon. All presentations today must be directed solely to the board and not to staff or members of the audience. All presentations to the board must also be only on those items before the board. Presentation on matters unrelated to the request will not be heard. The discussion of the Board of Adjustments may be appealed to the Superior Court of Pima County by filing a complaint for special action by the Pima County Superior Court Clerk's Office within 30 days of the board's decision. For additional information on this filing process, please contact the Superior Court Clerk's Office or an attorney after today's public hearing. If you are going to give testimony today, please be brief and to the point. Repetition of testimony already given by other witnesses is not necessary. The chair may invoke a time limit if deemed necessary. Before you testify, remember to please sign in on the roster sheet on the clipboard at the podium. If you are joining us remotely, please state your name and address for the record. All testimony to the board must be given under oath. If you're going to speak or think you might speak today, please stand at this time and raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
I do.
A reminder, please turn all cell phones off or to silent mode. If you are joining us remotely, please be sure to mute yourself and turn your camera off unless you are addressing the board. Mr. Castro, please call our first case.
Thank you, Mr. Chair and members of the board. Our first case today is C10-26-02, Enclaves at Tumamoc, lots 1 through 129, KB Homes, Tucson, 1802 West St. Mary's Road, R1 and O3 zoning. The appellant, Shauna West, is appealing the zoning administrator's determination TZ-CMP-1125-00197 issued January 22nd, 2026 regarding how the general plan and applicable or neighborhood plans are treated when applied to flexible lot developments. The zoning administrator determined general plan and area plan policies should not be treated as binding zoning rules for FLDs, and under Arizona law, the general plan and area or neighborhood plans are not zoning laws. And finally, the Tucson Unified Development Code is the city's enforceable land use law, which provides FLDs flexibility as it applies to UDC dimensional and design standards. The appellant contends that the policies, guidelines, and shall statements within the general plan and area plans are mandatory and enforceable as part of the zoning code. The appellant is before the board requesting reversal of the zoning administrator's determination issued January 22nd, 2026. The appellant identifies the following as the issues on the appeal. 1. Compliance with the general plan and applicable area or neighborhood plans is mandatory and enforceable as part of the zoning code and is not optional or advisory. 2. FLDs are intended to advance community goals rather than simply provide flexibility. And 3. Conflicts between the general plan or area plan and other UDC provisions are effectively internal UDC conflicts requiring stricter standards to prevail. In this case, that would mean the application should undergo further review and potentially additional requirements to ensure full conformity with adopted plans and the core purpose of the FLD ordinance. The zoning administrator's arguments to uphold the determination. 1. The general plan and area plan policies should not be treated as binding zoning rules for FLDs. 2. Under Arizona law and the Tucson Unified Development Code, the general plan and area or neighborhood plans are planning documents, not zoning laws. And 3. There is no actual conflict within the UDC that would require applying the most restrictive standard under UDC section 1.6.1. The flexibility built into the FLD regulations is deliberate and applies to UDC dimensional and design standards. Staff recommends upholding the zoning administrator's determination. It is the city's opinion that the prior determination issued January 10, 2019 is directly relevant and has been thoroughly vetted through the various decision-making and appeal bodies. To date, we have received a total of 15 written comments in support of the appeal. 2 of those are outside of the notification area. 9 written comments objecting to the appeal have been received. All 9 are outside the notification area. For the record, copies of the comments have been provided to the board members. Mr. Chair, this concludes staff's presentation. I would be happy to answer any questions.
Are there any questions? Okay, we have no questions. Thank you. Yeah, what's that? All right. Get my act together up here. I will now open the floor to anyone wishing to speak in favor of this this case. Please state your name and address for the record.
Mr. Chair, I believe we have the appellant who would like to make a presentation.
It would be nice if you came up to the microphone so we can hear you. The button there.
You're on. It's on? Okay. Perfect. Hi, my name is Shanna West. I'm the appellant. I live at 411 North Camino Santiago. I have a presentation. It's pretty dense. I do not intend for anyone here to read every word on every slide, but I wanted it there as receipts, someone said. If you felt inclined to read it, you wanted more context. I'm just kind of going to hit the screamers of it. So we can move on to the next slide, Mark. So I'm going to go through just real brief context. You were given during the study session an overview of what an FLD is. I wanted to just provide a little bit more context, one slide on that. I wanted to next go and talk about the distinction from the 2019 case with the Mountain View Neighborhood Association. I'll go through my appeal arguments, and then KB Homes submitted a letter and I wanted to respond to some of their asks as well. So if we can go back one slide, Mark, I apologize. I was just going through. Perfect. All right, so this is a snippet of a flyer. If you search flexible lot development and you pull up the City of Tucson's FLD page, this is the information that you're given. It's a 2-page flyer. You can see the example that the City of Tucson has given for flexible lot developments don't imply blanket increases in density, right? Much like definitions for FLDs, if you look up the within Pima County, Arizona, other cluster project definitions, the intent of a flexible lot development is to give the developer flexibility and creativity when the site has constraints that make development hard. So an infill site, it has significant topography, it has significant vegetation, there are architectural guidelines, whatever it may be, those things incur costs for the developers. So an FLD says, hey, you can develop at higher densities because you have to comply with those other things. And the example that the City of Tucson gave or gives in their flyer that was updated last in 2025, so just last year, shows an example of 30 lots on a typical subdivision and a flexible lot development still having 30 lots, smaller lot sizes though, so that we can preserve native vegetation, riparian areas, whatever might be constraining that site. So I just wanted to point that out as we talk through the rest of the code and the context here. Next slide. Perfect. You can move on to the next. So KB Homes supplied you with exhibits. One of them is the Arizona Superior Court ruling for the 2019 case. So if you want to reference that, you're welcome to here. But essentially, the summary of the case is that the Mountain View Neighborhood Association argued that the density designations within their neighborhood plan were violated and it constituted nonconformance. The Superior Court in their designation confirmed that FLDs are required to show conformance through basic harmony. However, the language in the area plan used words like generally appropriate and generally suitable, which imply exemptions can be made. So the Superior Court decided that they, in the absence of other disharmonies, simply not complying with the density regulations didn't create a wide disharmony with the area plan or the general plan, right? Because it had non-regulatory language. So if you move on to the next slide, this case, and the thing what I'm arguing is that one, FLDs are required to conform to the general plan and area plans per the UDC. This aligns with what the Superior Court stated, right? It has to show basic harmony. KB Homes is responsible for demonstrating conformance or basic harmony, and the city PDSD is responsible for assessing for conformance or basic harmony. I'm arguing that conformance to the general plan includes a demonstration of basic harmony between the goals, policies, and guidelines. And then I'm arguing that conformance to the area plan includes also a demonstration of that basic harmony, but also compliance to regulatory statements when applicable. And we'll get to that. But there are shall statements in the Tumamoc area plan and in other area plans throughout the city that should be treated as regulatory. In addition to those policies and guidelines that have more flexible language like generally, should, recommended, things like that. Next slide. So you can see that applicability of findings, right? I already kind of said that, but the 2019 case confirms that we do have to be in conformance with those plans. You do that through basic harmony. Non-regulatory language is treated kind of like a bucket requirement, right? You look at the macro level, do we comply with the goals and objectives and policies? However, the Superior Court did they didn't make a statement on it, but regulatory language or shall statements don't imply the possibility of exemption, so they should be treated as regulations, right? And failure to meet those constitutes a nonconformance, just like all other shall statements in any other piece of code. Right? Next slide. So the summary, the 2019 appeal, the scope was strictly on arguing these density recommendations, one line of code and it not being met. This appeal is talking about that conformance requirement, that area plans and general plans, or FLD shall be in conformance with the area plan and general plans. So we're looking at a UDC versus an area plan statement. The 2019 case proposed that when you interpret conformance, the recommendations in the area plan take precedence over the UDC requirement. I am arguing and have argued that conformance includes, by definition of the UDC, consistency. KB Holmes used the word basic harmony, so did the Haynes case that they referenced. So basic harmony with plans, goals, and policies. Regulatory statements, they shall be implemented. And if there's any conflicts arise that will create a disharmony at the macro level or conflict with a regulatory statement, then that has to be deconflicted per 1.6.1, which states that the more restrictive shall take precedence. And then just a little note, we're not looking at specific code here, but in the 2019, the density language in the area plans, in the Mountain View area plan was generally appropriate, generally suitable. In the Tumamoc area plan, density, it says that the following densities shall apply with response to certain zones. And then the other thing I did want to remind folks of is that the 2019 interpretation was not set as precedence by the zoning administrator. And the statement by the Superior Court indicates that their ruling was because it was neighborhood plan specific language that they were arguing or that they were deciding on. So while yes, the 2019 case is relevant, it was talking about specific area plan language, and we're talking more generally about the UDC and how you interpret conformance to that, and how you interpret conformance to that UDC requirement. Next slide. All right, next. All right, so talking about FLDs are required to conform to the general plan. This one's pretty short, move on. Awesome. So this is a screenshot of the UDC. The general development criteria for an FLD, the very first one states that an FLD shall be in conformance with the general plan and any of its components, including area plans and neighborhood plans. Note that this comes before the requirements to be applicable to other standards within the UDC, right? So for an FLD, they chose to make that the first criteria, not other UDC sections. There's a case there that says, and I can't read it, it's pretty, right? So we have to give meaning to every word, and determination or interpretation of that cannot render a word or provision superfluous. So we cannot effectively determine that that UDC requirement is not applicable. It's written. We can talk about how it's applied, right, and how we interpret it, but it is applicable. It needs to happen. So if we assert that the plans are not subject to review by the city of Tucson and by the developers, it effectively overrides that statement and renders it superfluous, which we can't do. Next. Again, there's a lot of text. I don't expect you to be able to read it. But this is the general plan or Plan Tucson of this year. It states multiple times in there that plan policy and review documents are used by the city when they're reviewing any sort of developments. So again, it doesn't say it's regulatory. It actually says it's not regulatory. Each plan or each policy and guideline isn't intended to be regulatory, but it is intended to be the starting point for review. And then if you look at how is Plan Tucson used, it says planning and development services, something uses it to review their developments. And in the second bullet, it says that property owners and the development community are also supposed to consult it when they're developing, right, to make sure that they're in conformance. Both of those are part of our Plan Tucson, or our general plan. So not assessing it against the general plan's land use policies and the neighborhood plan, it's a failure to conform to our development review protocol, which we have written here. Next slide. All right. So the argument that conformance to the general plan includes a demonstration of basic harmony. So if you move on. We've already kind of talked about this, but I just want to hit on in the same way that PDSD assesses other lines of the UDC, in the same way that a developer is held accountable for showing evidence that they've complied with 5-foot sidewalks or replanting of trees or whatnot, the developer has the responsibility to demonstrate that they're in basic harmony with the general plan and the area plans. PDSD has a responsibility to assess that development and confirm that basic harmony is achieved. That means reading the policies and guidelines and creating an opinion on it. And both are accountable to being able to prove that basic harmony is met and articulate that. And the screamer is like, if asked, they should be able to tell us why this is in basic harmony and how it meets that guideline. A little bit of background, right? And like, why am I here? I started emailing the city in the winter of 2024. So it's been a year and a half. It took 5 months or so, 4 months of me emailing and finally looking at an org chart and emailing everybody on that org chart blanket to get a meeting with the city on this issue. Because as the community, we were reading it and we said, we're reading the Tumamoc area plan and the general plan, and we're looking at the development plans that were presented in the neighborhood meeting, and they don't match. Like, it's not going to blend in with the community in a way that we thought the Tumamoc area plan states it needs to. We got a meeting out of that at PDSD, at the PDSD location in person. KB Homes was present for that meeting. We had some members of the community present, or of the neighborhood present, and several members of PDSD were there, so 10 to 15 people. And that was actually, I looked back on it, 1 year ago today, April 29th, 2025. In that meeting, a couple red flags. It was made obvious that they hadn't read the Tumamoc area plan. Like, neither KB Homes nor the City of Tucson Planning and Development Services had read the Tumamoc area plan at all in their beginning assessments of it. Multiple times we called something out and the response was, oh, I didn't know that. Or the response was, we don't have to comply with this per this 2019 case. It's not regulatory. So not regulatory as individual lines does not mean that at the macro level, conformance to the plan is not regulatory. Also, in that meeting, we were told that if we wanted to appeal the development package, the review of the development package, we could do that, and we would be helped in that process when the time came. So June hits, the time comes, ready to appeal it. The very first round of reviews happen, and I'm like not getting any responses to my email. Respond again, not getting any responses. I have to go to Mayor and City Council's Tuesday meeting call to the public to say that I'm not getting responses on this development package before I finally get a response. And the response is, actually, this is an administrative review and you can't appeal it. So all of, several months at this time has passed. KB Homes has put in time and money into it. We as a community have put time into it, and it's still progressing. So fast forward, months go by, I'm still emailing saying it doesn't look like the new development package has been resubmitted, isn't complying with the area plan or the general plan, it's not in alignment. Again, not getting any responses. I have to go to another mayor and council meeting to get responded to, in which case we have another meeting with the vice city manager and more members of PDSD. And again, they tell us that they don't have to assess against the Tumamoc area plan or the general plan because they're non-regulatory. And like 3 weeks later, KB Homes broke ground on grading the property. after we were told we couldn't appeal. It wasn't until I started going through the City of Tucson website and code trying to figure out what I could do that I realized that I realized that the 2019 case was not set as precedence. So all of this time they said that it was a precedence decision that they're going off of. I realized it wasn't, which means I was allowed to do another zoning determination on it. So that was submitted in November. And then it was supposed to take 30 days, right? Per the policy, you have 30 days for them to get back to me. At like the day before the 30-day mark, I get a thing saying, this is a complicated case. Per the UDC, we have 45 business days to respond. And that's how we got to like the end of January before I was finally able to have a determination that I could appeal to get here today. So it was not my intention, nor the community's intention, for this development to have progressed this far, for KB Homes to have incurred these costs, or this development package before we got to a point that we felt like we could talk about it. And I just, why am I arguing this, right? When clearly the 2019 case said that basic harmony is part of conformance, or that's how you assess it. And it's because it's been demonstrated time and time again by both the developer and PDSD that they're not assessing it to basic harmony. That conformance line, they're just writing off as not something that needs to be looked at. So next slide. Okay, conformance to the area plan. So this is where it gets a little different, right, than what the 2019 case is. So next slide. So per Arizona revised statutes, authority and scope of specific plans, I included the link here. If you have access to this page, you can go there and see. It says that specific plans may, in addition to recommended zoning ordinances and subdivision regulations, include regulations on locations such and such, regulations, right? It states that specific plans may include additional regulations. Specific plans can be regulatory. Now, is the language in our specific plans, our area plans, are there a lot of shall statements in there? No, they're mostly guiding documents. But there are shall statements, there are regulations, and that is per the Arizona revised statutes, in addition to the zoning ordinances and subdivision regulations that they're already have to comply with, right? So all of this time we're being told that area plans are not regulatory. Policies, guidelines, suggestions, goals, absolutely. Per the 2019 case, per other cases, yes. Regulations in the area plans, no. Those are regulations just like other regulations in the UDC, just like other regulations in code that are referenced by the UDC for being in conformance with. Next slide. And the general plan and area plans support this, right? Again, I don't expect you to read this or be able to read it. I can't. The 2021 general plan states that plan policies are used to formulate staff positions on residential cluster projects. The 2013 general plan states that plan policies or specific plan policies are consulted for the primary guidance on other discretionary land uses. And should interpretations arise in the policies of the specific plan will take precedence. The 2025 Plan Tucson says that the implementation of the goals and policies are undertaken through more detailed planning. And it goes on to say, detailed plans relating to a particular geographic areas, like neighborhood plans and area plans. So even the general plan supports that specific plans are the implementation mechanism for some of those goals and policies that aren't regulatory, that are assessed, like I said, at that more macro level. Next slide. And these are just kind of, I picked a random assortment of area plans. There's a list on the City of Tucson website. And consistently, they state that they're used for the assessment of, most of them say residential cluster projects. That's what FLD was named prior to being renamed as an FLD. So if you see residential cluster project, it means flexible lot development, right? Clustering of higher density homes. So all of the adopted area plans that we have, or a majority of the adopted area plans that we have, call out their use as a mechanism for reviewing residential cluster projects or FLDs. So again, our plan, our policies support them as being a mechanism to assess conformance. Next. The last thing that I think is really important, it's a small thing, but in Plan Tucson, in the implementation page, it talks about major amendments to Plan Tucson and the general plan. We're required to have a general plan per Arizona revised statutes. We just had one voted on this last year. Major amendments don't happen very often, but the very first bullet there says that a major amendment is necessary to Plan Tucson if the site of a development proposal is not covered by an adopted specific plan. So this just goes to show how important specific plans are to the development review and to the progression of our general plan and our city's development process. Right, it constitutes a major amendment if there's nothing for our planning and development services to assess against, right, from a specific plan perspective. So they're important. Next slide. And then response to some of the stuff that KB Homes had mentioned in their letter. So next slide. They talk about, oh man. Arizona legislature requires the city adopt its zoning regulations by ordinances and not resolutions. And then they quote an Arizona revised statute. I included a link to that there. If you read it, there's nothing in there that says that's the only mechanism for adopting zoning ordinances and regulations. It says that the legislative body of a municipality may, and it goes on to describe the regulations and the process for doing that, but it doesn't state that it's the only mechanism. In fact, bullet F within that Arizona revised statute states that all zoning ordinances need to be in alignment with the general plan, and that there should not be, and you can read some of the subtext there, there should not be anything contradictory to the plans, and it even says goals, implementation of and not be contrary to the goals, policies, and applicable elements of the general plan. Applicable elements including specific plans and other plans within it. So it's not the only mechanism, right? There are other ways that you can get zoning regulations and ordinances. Next. They also state that the Tuamac area policy language is, for lack of better words, coming to me wishy-washy, right? Should, when possible, encourage, and that's the only language, which would be impossible for them to assess against, but that's not the case, right? There are shall statements in the Tuamac area plan, and I pulled up a number of other area plans just because I was interested, and there are shall statements in those area plans that are unique to the area in question, right? Depending on the characteristics and what that area finds important. So it's not only those kind of guiding statements that are included in area plans, there are regulations. The other thing that I want to mention is some of them might be hard to assess, but some of them like encourage design that complements the surrounding development using compatible setbacks and variation in building height or whatnot, that's accessible. I think that most of those, while they are suggestions or they use suggestion language, they're kind of binary. Is it or is it not? Did they or did they not? Some of them are judgment based, but it's not unenforceable or impossible to assess, right, from a development perspective. Just not regulatory on a line-by-line basis, right? You're looking at the whole picture. Are they doing things generally? Next. They also state that for sub-area 15, and this is one of the areas of contention. I know we're not arguing code, but they mentioned it. Mid-urban densities are appropriate. And that is true, but there's a policy that states for development plans for, I can't read it very well, but essentially it says that recommended density limits shall apply for those sub areas. That's the recommended density limit. But it also says that other policies in this plan take precedence when those recommendations take precedence over those recommendations in the event of conflict between adopted policy statements and recommended density designations. If we go over to the right, which I know you can't read, but that's where it said the following density categories shall apply. And it goes on to state that for an R1 zone, and you can move on to the next slide because I think it just duplicates it. For an R1 zone, you can only get that 6.25 that a flexible lot would allow if 40% of the site is preserved as natural undisturbed open space. And this aligns a lot with the example that the city of Tucson chooses to put on their flyer, right? Which is to say, yes, absolutely, you can develop at higher densities in the Tumamoc area if you have to preserve all of this vegetation. Otherwise, 2 to 4 homes per acre is appropriate for R1. So the Tumamoc area plan even aligns with the intent statement of an FLD, right? So again, the regulations here, the shall statements here align with the general plan, aligns with Arizona revised statutes, aligns with the definition of an FLD and how the city of Tucson has chosen to market an FLD. So we have to assume the intent is for them to apply, right? For us to take this shall statement and regulation as it is. Next. They also listed, the Plan Tucson gives examples of how it should be used, and it includes these 3 bullets. There's 3 more bullets to that list in Plan Tucson. The 4th bullet is the Planning and Development Services uses it for review. The 5th bullet is that development community use it for review. And then the 6th is that like community members use it for progressing the policy. So just a little note there that they chose to omit the 2 bullets there that talk to the responsibility of planning and development services and them as the developer to consult it. Next. They also stated that the Tumamoc area plan's purpose statement reinforces unequivocal language, reinforces that it's only supposed to provide guidance by saying things like it provides design guidelines for the development. But the purpose statement of the UDC has the exact same language. The first one says that it guides new development, right? Nowhere in the purpose statement of the UDC does it say it's regulatory. And that's because a purpose statement, just like was stated earlier by our old zoning administrator, is intended to exemplify the intent of the code below, right? So the purpose statement of the Tumamoc area plan doesn't state that it's regulatory, just like the purpose statement of the UDC doesn't state that it's regulatory. So just going on there. Next slide. It's the implementation intentions actually that are a better understanding of how it's intended to be implemented, in which you can see here, I already commented on it earlier, but plan policies are used in the evaluation of residential cluster project subdivisions. So the implementation section of the Tumamoc area plan does state that it's used for flexible lot developments or cluster projects. Next slide. KB Homes also stated this basic harmony, right? The 2019 case stated that you needed to provide basic harmony, and that was sufficient for proving conformance to the general plan or the area plans, which I agree. I am not a planning and development services person. I am not here to state that my interpretation is blanket truth. I would want it to be reviewed, and that's what we're asking. But when I read the Tumamoc area plan, 21 of the policies and guidelines, I think I interpreted as being applicable to this development. Not applicable, maybe it mentions a wash that's not in this development, something like that. Only 4 of them I felt confident that this development met. There's 4 that I was unsure about. Some of them like only landscape with native plants. I don't know if they are. There are 13 that based on my view of the development, we are not in conformance with. So I don't feel like basic harmony has been achieved. And when I sent that list of Tumamoc area plan policies and guidelines of the design guidelines plan to the city of Tucson, I kind of got like a, not literally, but arrow down for anything that they didn't comply with. They said, it's not regulatory, we don't have to assess against this, which is not the truth, right? You still have to look at each individual line and then look at the composition and say, does it achieve basic harmony? So the Tumamoc area plan, it emphasized the emphasis in the whole plan, if you've been to the Tumamoc area, right, is on the protection of existing communities of vegetation, wildlife, and residents. So all of the policies and guidelines in that plan talk about preservation of native vegetation, maintaining wildlife corridors, matching architectural styles with existing residents, because it is all built in the 60s. So single story red brick homes, flat roofs, larger lot on a hillside, right? Hopefully you've been to the Tumamoc area. It's beautiful. Next slide. So a little bit of additional background, just because KB did provide it. I wish I could kind of point, but so that is a screenshot, or that's a picture from hiking Tumamoc Hill. This to the right, you can see it. You know, I'm just gonna, hopefully you can see this St. Mary's Hospital. This is the development. This angle for you. Purpose of that is when you're hiking Tumamoc, especially the latter half, you're closer to this development than you are to St. Mary's Hospital. And people park at St. Mary's Hospital to walk it, right? So you heard objections and support from people in the neighborhood. You heard it from the developer, but thousands of people every week hike Tumamoc Hill. And this is the closest thing to them, and arguably one of the most visible developments in the city of Tucson. People see it not only when they're going out to Gates Pass, when they're going to Pima Community College, but they also see it from the sky, which you don't see very often, or we don't experience very often. And those pictures to the right, they show what the plot of land looks like before it was graded. So you can see mature trees, super dense vegetation. When you're walking on the road, you wouldn't know if there were a pack of javelina there. So next slide. It has been graded, completely graded, flat, well, not totally flat because it's in a floodplain, so it needs to be able to drain into the wash. But it's not a hillside community anymore. And there's not any native vegetation there. So for thinking about our community, not just the residents who are right next to it, but also the folks that are going to be climbing Tumamoc Hill and seeing it. If you look at that aerial shot, you can see the proposed densities is double the surrounding area. They're majority 2-story, not all of them, but majority 2-story, pitched roof homes. Everything in the surrounding area is single story, red brick, flat roof or built up roof, so the white roofs, you can see it here. And what that allows is preservation of vegetation or revegetation. So you can kind of see, and I know it is a little bit hard to see, but you can see the trees poking up from the top of all of these homes. And you can see it when you hike Tumamoc. And what it used to be when you hiked Tumamoc is that you paid no mind to that plot of land. And that's how it should be, right? It should be that when you're driving down the road and you're walking Tumamoc, or you're doing anything in which you want to enjoy the scenery, which has been outlined in the Tumamoc area plan as a primary purpose for it, is preserving that. It should be that you don't notice anything because everything is so similar that it just is a non-issue, right? And we have asked as a community for more strict enforcement of architectural compatibility, more strict enforcement of vegetation protection, more strict enforcement of anything in the Tumamoc area plan in order to preserve this plot of land that's very, very public. And we have been met with, it's not a regulatory statement, so we don't have to assess against it or do it. Next. And this is more so me just providing context on why we're coming here. Like why even talk about basic harmony when the 2019 case already stated that it needed to have basic harmony? And it's because it's not being interpreted as being a mandatory thing to look at. Again, this is my interpretation. I'm not stating its truth completely. I'm a community member, but similar thing with Plan Tucson, right? A lot of it's not applicable, like transportation stuff. There's only one that I feel confident it is in complete harmony with. There's a couple where it like, yes, some things, no, some other things, so 50-50. And then of the 6, half of them, I couldn't find anything that it was in harmony with. So to a reasonable person, and then back to the FLD purpose statements, right? The UDC is intended, we talked about it, right? Like what's the purpose of the purpose statements if not to assess against? And it's to provide the intention of the code below. Of the 10 purpose statements, I would say like 7, I put it in my appeal, 7 or so of those don't have a UDC regulation associated with it. They can only be fulfilled through goals and policies and guidelines of the general plan and of the area plans. Therefore, it should be interpreted that that line, an FLD must conform with the general plan and area plans, is intended to be followed. Otherwise, those 7 purpose statements aren't under review. There's no way to achieve them, or there's no incentive to achieve them from a developer because it costs money or it loses money or whatnot, right? It's not easy. Next. And the last thing was KB's response saying that they have a vested right to develop. So KB Homes has been involved either directly or indirectly with all of the conversations that we've had with the city of Tucson up until this point. We've actually met with them in person alone in the fall of last year. They are very aware of the community concern about conformance with the Tumac area plan and the general plan. They have chosen to continue their development despite knowing that their development package is still under review and it could be appealed for this, right? Their decision to continue development is reflective of their own risk posture, and the city and the community should not be held accountable or responsible for incurring any of the expenses of that risk posture. So should this appeal, and the other thing is, when I submitted this appeal, yes, they had graded, but very, very little inline utility or in-ground utility work had been done. Like we have pictures in the background that show the start of some of it, but most of it has happened over the last 2 months, 2.5 months. So they're aware that if this appeal were to be successful, that changes to their development package that would constitute differences in how those utilities are laid or vegetation or whatnot might happen, and they've chosen to continue. So that shouldn't be on us to like influence our decision on whether or not this code needs to be enforced or not enforced. So I just wanted to make that known. And then the next slide. Next slide. And just kind of like a note is that despite everything that's happened, right, despite it being graded, which, and the vegetation being completely gone on those, I should say 19 acres. So roughly 13 acres of it was the R1 zone that was predominantly native vegetation. I wouldn't say it's undisturbed vegetation because I think 60 years ago it was probably disturbed, but it hadn't been touched since then. 13 acres of it was that, and then about 6 acres was the office space building, right? Harmony can still be achieved. There's still things in the Tumac area plan and the general plan and design guidelines manual that is called out in the general plan that they can do. So them saying that we've already graded doesn't necessarily mean that they can't still reach harmony. They can revegetate. That is possible. They can look at their architectural plan and architectural variation and look at single-story homes. They actually developed under the flexible lot development code, another development in the Tucson area that's all single-story. It's an FLD, and they preserved a good amount of the wash, and they created wash buffer zones. So they've done it before, and they can continue to try and achieve harmony, even if the site has been graded, right? That's not to say that it's a wash and all of their costs are unrecoverable or wasted. Next. So the decision points here, I think decision points meaning like you as board members need to decide on how you feel about these things moving forward. But one is FLDs are required to conform to the general plan per that UDC statement. Doesn't talk about what conformance looks like or how you assess it, but per that UDC statement, they are required to conform to it. 2, FLDs are required to conform to applicable area plans per the UDC statement. 3, conformance to the general plan includes demonstration of basic harmony with the goals, policies, and guidelines. 4, conformance to the area plan includes demonstration of basic harmony to the goals, policies, and guidelines. 5, conformance to the area plan also includes compliance to regulatory or shall statements when applicable. And 6, if other UDC provisions compromise basic harmony or conflict with regulatory statements, then the more restrictive takes precedence. And I just want to acknowledge that it's unlikely that one UDC provision is going to throw off an entire thing of basic harmony. However, if we're looking at hypotheticals and how we're interpreting the code, it should be interpreted as such. If you can prove that maybe an area plan, all it talks about is 10-foot sidewalks, and the UDC has 5-foot sidewalks, that would constitute a conflict of basic harmony, right? If that is the only thing in the goals, policies, and objectives. So I do want to make it known that while it's unlikely that basic harmony will be compromised by one UDC provision, I do want it to be decided on by the board that if it should happen, the more restrictive takes precedence. In addition to the shall statements, which are not part of the basic harmony bucket, but are rather interpreted as individual lines, right? Next, and then my ask, which I included in it, is that we ask the development be reassessed for conformance to the general plan and Tumamoc area plan, specifically for the policies, design regulations, and shall statements, and very strong or strong statements of policy commitment to the city of Tucson. If conflicts arise when ensuring conformance to those plans in other areas, the more restrictive shall apply. The other ask that I would like to make in terms of follow-on actions, just based on the nature of our relationship with the developer and with PDSD, we do ask that should the board approve this, that PDSD provide justification for their assessment of conformance, including a list of the goals, policies, and objectives that it meets, does not meet, and kind of an overall statement on why they think it still achieves basic harmony. And while that wouldn't normally be required, we don't have a lot of confidence or faith, right? Like our trust has kind of been fragmented. So we would like to make sure that it's, we're compliant with the UDC. So I believe that's the conclusion of my presentation. Are there any questions?
Are there any questions for the presenter?
No, I would just say that was a very thorough and well thought out presentation.
Yeah.
A lot of what you said is in conflict with what the city has said to us. We're going to have to consider that along with the input we receive from many other parties, and we'll have to come to a decision. But I just wanted to first tell you that I personally am very impressed by the presentation.
Thank you. And just to comment, the city has stated, and we agree with, that each individual policy, guideline, recommendation is not regulatory, but instead it's the composition of those things, right? At the macro level, can we show that a majority or that the intention is being met or the goals are being met? So not totally in conflict, but maybe in conflict of intent or of application, right? I agree.
Any other questions? Yeah, I have one. It's obviously you're not real happy with what KB Homes is doing.
I think, and we've met with other members of the community, we always expected the land to be developed. So it's not necessarily the existence of a development. I mean, it's kind of a bummer, right? When you're looking out on desert and then it's going to be developed. But we knew that was going to happen. So again, it's not fact of a development. It's that the development doesn't meet what we expected when we moved into the area. And if you look at the area plan and what we expected for future development and what we were under the impression that we were being protected against as communities and neighborhoods there, or neighbors there. So it's like I said, it's not the homes necessarily. We need homes. We knew it was going to be developed. The office spaces had been abandoned since 2020, so they were becoming rather dilapidated. But it's rather that the development isn't being done in harmony with existing residents, it's not preserving native vegetation. It's not following any of the goals and guidelines of the general plan or of the area plan, with the exception of its infill, which we want to encourage. Everything else has kind of been thrown to the wayside because it's not regulatory.
Any other questions? Thank you very much.
Thank you.
Is there anyone else in the audience who wishes to speak in favor of this?
I would like to, please.
I'm sorry, what?
I would like to speak. I'm on Microsoft Teams.
Okay,
My name is Amanda Schreiber. I'm a neighbor in Santiago Hills.
okay.
Thank you, Mr. Chair and the board. Thank you for considering our appeal. I'm fully in support of this appeal. I consider it an honor to live in a neighborhood that is one of the oldest inhabited neighborhoods in the United States. I want other people to have the experience and feeling of kinship and neighborhoodism that I am so lucky to feel every day. I am not opposed to new homes being built in our neighborhood, and I fully support the city of Tucson's push for flexible lot developments, especially to create housing that our city so badly needs. However, I do speak up when I hear someone saying that this is just the way it's always been done, or there is precedent for this, but are unable to support those statements with actual evidence for best practice or cite to true precedents. I believe the area plans, especially the Tumamoc area plan, were put into place by neighbors before us who felt the same honor that I feel about living here. At the base of Tumamoc Hill or in their own beautiful area of this city, they took their time to create these plans as a way to show how much they care for future generations of neighbors. I do not think area plans should be so easily discarded, and I do believe we owe it to Tucsonans who came before us to respect their vision for the future, because we are living in the future that they envisioned. Our neighborhood has asked the city of Tucson to hear us out for over a year about this, and while we are grateful to you for hearing us now, after being incredibly squeaky wheels and paying a large sum of money to be here, we are willing to forgive past dismissals if you are willing to write this by hearing us out now and taking the Tumamoc area plan seriously for what it is. Guidance for how to maintain the dignity of our beautiful city, the beautiful people who live here and want to purchase a home in our neighborhood. There is no dignity in the demolition of these 19 acres to build the structurally unsound, cramped homes that KB Home is selling. We want better for our new neighbors and for our old neighbors who envision something better for this city. Thank you so much.
Thank you. Are there any questions for the? Okay, thank you. Is there anyone else wishing to speak in favor of this? Hearing none. Okay, now we'll open the floor to anyone wishing to speaking in opposition.
I would like to speak in support of the appeal.
Okay,
Did I lose my chance? Did I not stand up fast enough?
just about missed it, but okay.
I hope the acoustics are better in there than they are back there. It's hard to hear. This poor fellow is, oh, he's on his laptop. How's it going over there? I live in the neighborhood, and mayor and council sold us the general plan, which we paid for. And I haven't seen a single mention of it in any of the KB literature. It's not in there. All the flexibility is for the developer. And the only thing that the city is doing right now is protecting the legal status of the flexible lot development. That's it. I have seen nothing regarding the general plan except for economic development. And the economic development doesn't benefit the city generally. It benefits the builder, the county, and property taxes. That's it. And right now it is a scar on the desert. They bulldozed everything. Not a single tree was left. They've driven over it hundreds of times. That soil has been turned to nothing. The open space that we're going to get, just like the mountain enclave, from the 2019 appeal, which may be revisited here. The open space is mostly the driveway between the carports. There's a tiny little courtyard in the center. It's like a battleship has been dropped into the middle of the desert. It's disrespectful, and it has nothing to do with the general plan or the area plan, which we paid for. It was sold to us by mayor and council who appointed you. So do you want to govern, or do you want to be the attack dog for the developer? Thank you.
Are there any questions for that presenter before he gets out of here? All right. I don't hear any questions. Thank you. All right, now I will ask for
Gentleman in
anyone,
the back.
and come forward. State your name and address, please.
Hi, Paul McEwen, 411 Camino Santiago. As a community member who's been watching this development occur, we've got a front row seat. Our window looks straight out at the development. I'd like to say that I've been watching the email traffic between the city and KB. I think it joined in on that email traffic around 2025, but the community meeting started in 2024 when this development was started, for lack of better terms. And since then, we've been trying to work with the city as well as coming to the call to the public and trying to bring awareness to the situation that we're being interpreted away and that we don't know what we're talking about. But as Shanna West has presented to you guys, the code does, or I don't want to act like I know the code. I'm not a city council or part of the city or anything like that, but it pretty much presents the fact that this should be looked at least looked at for conformance, because the email traffic has said this is how we've always done it. We don't need to look at this. There's nothing new here. But I'd like the board to please reconsider, because this is all of our communities, and this is a potential for future developments. KB Homes is a national developer. They've got a lot of lawyers and people behind them, and they can keep steamrolling our community with developments that don't fit what our communities have voted for. Thank you.
Any questions? Okay, none. Now, anyone else wishing to speak in favor? Okay, hearing none more, I will open the floor to anyone wishing to speak in opposition. Please state your name and address.
Sure. Mr. Chair, members of the board, I'm Rory Juneman, 5983 East Grant Road. I'm an attorney, land use attorney here in Tucson. Our firm specializes in land use law, so we're very familiar with this area. We're representing KB Homes. There's a lot of folks from KB here. I do want to take issue with something that was just said about KB steamrolling. KB is one of the few developers or residential developers who does infill development, which is needed, extremely needed. They like those sites. They do a great job on those sites. They're excited about bringing homes into the city at a density that's appropriate for the area. So I just want to, let you know that KB there are people that are excited about bringing homes when they're needed. There's 129 homes in this development. Right now, there's 380 people who have signed up and interested in them. They've gotten much more interest in this location than they have on other recent ones. I go to Tumamoc all the time. I think living in this area would be fantastic just because of the availability to recreation, to downtown. It is an area that is very well suited for this development and appropriate for this development. So I want to start off with that. I want to, the presentation that you just saw was very good. It was very complicated. And this is not a complicated case. This is a case that I think is very simple. It really focuses on one provision in the UDC, which is the FLDs shall be in conformance with Plan Tucson and the applicable area plans. And the question here is even simpler. It's what does shall be in conformance mean? You all are lucky because this question has been asked back in 2019. The zoning administrator at that point answered with essentially a general conformance standard. Shall be in conformance with means a general conformance standard, or basic harmony is also used from state case law. After that, the board, the people that were sitting in your chairs back in 2019 affirmed that. And then it even went to a state court judge who affirmed that zoning administrator decision. And now the latest zoning administrator has basically agreed with that, brought forward that precedent. So I think your job may be pretty easy. All you have to do is listen to what those before you have said, listen to that precedent moving forward. What I'd like to do today is just kind of tell you why that precedent, why that decision was the right decision. And it starts off really with the framework of zoning regulations. So I have one slide here for you that kind of walks through that framework. At the top of that framework are overarching policies. The general plan is at the top. That's required. Each city and town in the state is required to adopt one, which by now they all have. And then every 10 years they've got to revise that plan, which the city just city voters just voted on that this November, and now we have a new 10-year plan. Under that are more specific area plans and neighborhood plans, but those are designed for guidance to guide the city as they grow, as the city makes decisions on how they grow. It's advisory. It really is in place to help with growth and help with the city make the laws and to make their laws. So down below is zoning regulations and building codes. Those are the actual laws that govern the city. The planning policies are there to help guide that, but mayor and council adopts those laws as ordinance, or adopts building codes through ordinances. This framework has been in place for decades, and what appellant is asking to do is to really now sort of collapse that framework to where some of the regulations or all the regulations are equivalent to the laws. And that's just, first of all, it's just not legal, and two, it's not practical. So from a legal standpoint, Plan Tucson and the Tumamoc Area Plan and other planning documents are adopted by resolutions. Those are official acts of the mayor and council, but they're really done more for policies, for for other sort of proclamations, things like that. For ordinances, the city is required to adopt those, or for zoning codes, the city is required to adopt those through ordinances. The appellant back on her slide 21 argues that regulations can be regulatory, that basically doesn't follow the statute. The statute essentially says that a city may regulate zoning regulations, may regulate land use. It doesn't have to, or it can choose on which areas that it can regulate. But if it does decide to regulate an area of land use, it must adopt that regulation through ordinance. And that makes sense because ordinances are held to sort of a higher legal standard. Ordinances must be definitive. They must be able to be understood by those who are following them and those who are regulating them. It's just, it is clear law that that land use regulations must be adopted through ordinances. The planning policies at issue here are all adopted by resolution. They are not adopted by ordinances. So the city does not have the authority to to put those regulations in a kind of a regulatory position. They simply just don't have that authority. The Arizona courts have also looked at this for a little bit different reasoning, but what the courts have said is far back as the Haynes case in 1986, which appellant mentioned, is that any kind of planning policy must be evaluated. The standard for review is a general conformance standard, a basic harmony standard. So Arizona courts have decided this. The statutory structure of ordinances versus regulations are clear that the city does not have the authority to regulate those planning policies because they're not adopted as ordinances. The second issue here is that it's really not practical to regulate these policy statements. Policies are written not to be enforceable, they're written to be guidance. The purpose in the Tumamoc Area Plan, there's intent statements over and over that say these are guidelines to help formulate later decisions, but they are not regulatory. Actually, the newly adopted Plan Tucson states specifically it is not to be a regulatory document. It is for guidance only. So this is really best sort of illustrated by the language in the Tumamoc Area Plan. There are a few policies in the Tumamoc Area Plan that that have some shall statements but the vast majority of those statements are more general, well, I'll give you some examples. New subdivisions, including single-family detached developments, should provide major street frontage buffers landscaped with native plants. This doesn't say that the project must have buffers with native plants. It says that they should be. They should have those. Another policy, encourage design in new development, which complements the surrounding development by utilizing compatible setbacks and variations in building heights or mass. This policy statement encourages it, doesn't require it. There's some other language specific to our project. We're in sub-area 15. Appellant mentioned this. If the area northwest of St. Mary's Road is developed for residential uses, which that's our project is doing that, then mid-urban densities are appropriate. They're not required, they're not prohibited, they're appropriate. So this is language that a developer can't follow to design to a specific plan, nor can staff enforce that. It is policy language for guidance. Ordinances are different. Ordinances are designed to be law. They provide specific, clear, and definitive requirements. Examples are 1 canopy tree shall be provided every 40 feet of pedestrian circulation system. That's clear. It's understood by the designer, by the engineer, the architect, and it's understood by city planning development services reviewer. Another example, all elements of an FLD, including residential units and recreational amenities, shall be connected by a pedestrian circulation system. That is a clear statement of what needs to be followed. It can be designed to that level, and it can be reviewed and approved at that level. I make the analogy to a speed limit sign. A speed limit sign doesn't say the speed limit should be around 35 miles an hour. It says the speed limit is 35 miles an hour. It's clear for the driver to know what that speed limit is. It's clear for the police officer to know what that is. The same with ordinances. They need to be clear. They cannot be vague, and they need to be understood by those that are the property owners and the people reviewing. Finally, I want to respond to one of the things that appellant had mentioned. Her slide 31, she talks about plan conformance with the general plan. And then I believe she also summarized what she thought were the plans in the Tumamoc Area Plan that we complied with and didn't comply with. there's some issues with, particularly with her analysis of the general plan. This project was submitted and approved under the 2013 general plan. That the 2025 plan wasn't approved until November. By then, KB had their permits, had started construction. So what the appellant did her analysis under for the general plan was a 2025 plan. So that was incorrect. She also didn't look at any of the there's a whole set of development policies in the general plan that she didn't look at in the 2025 plan. But what we have done is we went ahead and we've done that analysis. And so I'd like to pass that out to you all. Just for under our analysis, under the Tumamoc area plan, there were about 43 policies or sub-policies. There's some policies that had multiple sub-policies to them. With our analysis, we comply with about 29 of those, and we didn't comply with about 4 of those. Under Plan Tucson, there's about 39 policies and sub-policies. We complied with 11 and didn't comply with 2. In Plan Tucson, there's just a lot of policies that are much higher level than an individual development. So a lot of those just didn't apply, and some in the Tumamoc area plan didn't apply either. But I'll go ahead and pass this out. Mr. Castro, you've got that, and if you could email that to the other board members who are online, I'd appreciate it.
Yes, I'll do that. Thank you.
So my intent with this wasn't to go through and take the time to talk about every plan policy. Really, what I wanted to show is that we have taken the time to look at those policies. We believe that we easily meet that basic harmony general conformance standard, but admittedly, we don't meet every plan policy, right? That's not how this is designed to work. So if you have specific questions about any of them, we're happy to answer those. If you have specific questions about anything else that appellant brought up, if you'd like us to respond to those, I'm happy to do that. But in the interest of time, I'll just kind of wrap up by saying that appellant's arguments here are simply wrong from both a legal and a practical perspective. The city does not have the authority to regulate policies that have not been adopted by ordinance. And the practical reality is the policy language is, in a lot of cases, so vague that it's unenforceable. So with that, we would respectfully request that you deny this appeal, that you uphold the zoning administrator's determination and follow the precedent that's been set before you. So thank you.
Are there any questions?
Yeah, I do have one I'd like to ask, and I appreciate the work you've done in terms of identifying which plan policies you conform to or not. But is it not your position you do not need to comply with the area plan at all, just like the city is saying in their decision?
So, Mr. Chair, Mr. Marks, I don't think that's the city's position. I think the city's position is that an FLD, and maybe I'm wrong, but an FLD has got to have a general conformance with the planning policies. And that I think that was signified through the approval, through the extensive reviews of the project. So our position isn't that we are ignoring those policies. Our position is that we conform with them, and we more than meet that basic harmony general conformance standard that is the law. Our position also is you can't just turn regulations that are you can't turn planning policies into regulations because it's just straight up not legal. They weren't approved in the method that allows them to be laws, and they weren't drafted in a way, most of them, where they can be regulatory. So, so I think by looking at what we handed out, I think we easily meet and conform with those plans. So,
Okay, thank you.
I have a question.
Mhm.
How do you respond to the statement the appellant made that KB Home didn't spend any time trying to reach out to the community or talk to the community, and that they were begging the mayor and council to be involved in the development?
Yeah, we vehemently disagree with KB not reaching out to neighbors. KB's been working with neighbors for the last 2 years. Kelly Lee's from KB, and she can kind of explain that. We're not sure, you know, we're not involved with the direct communications between the neighbors and the staff, so we can't address that. But we can definitely give you a little bit more information on KB's efforts, if that's okay.
Yes, please.
Can I have one more question for you, sir?
Yeah, sure.
Can you reiterate what you said, something about the 2025 versus the planning process that you were under prior to that the appellant is questioning there?
Sure. Appellant on her slide, Mark, or Mr. Castro, I don't know if you want to bring that up, but I think it's her slide 31. She does kind of a table analysis similar to what we did. And there she uses Plan Tucson goals 1 through 14. Well, from what I could tell, that's not cited, so I'm not 100% sure, but I went back into both the 2013 Plan Tucson, which is what we were subject to. We were essentially, when we got our permits, the 2013 Plan Tucson was in effect at that time. The 2025 had not been approved by voters until a month or so later. So I believe she used the 2025 plan to do her analysis of what we comply with and what we don't and what's not applicable. What I wanted to make sure, just to be clear on, is we use the correct plan to analyze conformity. We broke out every land use policy, and those are the ones that are really applicable to developments like ours. We broke each one of those out, looked at those, and marked out where the ones that weren't applicable, which was a lot in Plan Tucson because it's a higher level plan, and then the ones we conform with and the ones we don't conform with. We did the same thing with the Tumamoc area plan. I think the slide or two before she mentions that, and there's seemed to be a lot more policies that we looked at than she did. So I think we did a very thorough job of that analysis to show that we conform with both of those applicable planning documents as is required by the FLD. But we looked at it from a general conformance standard. So.
Thank you.
Mhm.
Are there any questions?
Yeah, I have one more question. She spoke about the architectural dissimilarity between the KB homes and the existing neighborhood, and there is a significant difference between those. How do you respond to that?
Sure. Maybe Kelly wants to address that too, but I'll take the first stab at it. And so, Mr. Chair, Board Member Schaaf, sorry about that. So I think the reality is those homes are they're mid-century homes, right? They're decades old. To expect that a new development would come in and mimic those homes around, I think is just not realistic. It also, the homes these days are specifically designed, they're specifically crafted for things like energy efficiency, for more density. They're just a different product. I will say this: seeing the picture of the graded land it's stark, right? It's just been graded. in 2 years, if this, hopefully this will be built and you'll have 129 families in there, it's going to blend in like everything around. It will become the new context, the new norm. So, the picture is something that does sort of stand out, but that's temporary. The reality is, for decades, you're going to have families living there in a great part of town, accessible to Tumamoc, to downtown, to all of those things, living there just like the current people that live around do, right? They've got a great thing. What KB wants to do is bring in 129 families so they can experience something similar.
Okay, thank you. At the end of this, you may rebut. Okay, thank you. Would you state your name and address, please?
Okay, Kelly Lee, 1650 East River Road. I am the Senior Director of Forward Planning for KB Home, and also a business owner in the Tumamoc area, and also have lived in that area for over 25 years, and obviously care deeply about the area. I think it's important that we answer Mr. Schaaf's comments about the neighborhood outreach, because I personally took it upon myself to go above and beyond meeting with these neighbors. So, for instance, when we first approached the property owner and wanted to buy the property, we understood there was a vacant building there. And by the way, my whole KB team is here to support and cares deeply about the Tucson community and the results of the Tumamoc community, and supports a great development here. So I just wanted to mention that. But when we approached the property owner here, there was 2 vacant buildings. There was a hospice building that's 60,000 square feet. There was also another daycare facility right next door. And it was all boarded up. There was fencing around it. So to even get on the property was a little scary. The hospital group did have people monitoring it, but it wasn't 24/7. So as we entered into escrow and went through our due diligence and got to neighborhood meeting, which we talked about already with Ms. Hamlin, is an FLD requires a neighborhood meeting. It's an informational meeting. We had this meeting at the school down Anklam, and I think we had numerous neighbors show up. We talked about a lot that night, a lot of the concerns, some of the stuff that Shanna has talked about, and since then have worked to communicate with them and address their concerns. So, for instance, the buildings were vandalized. There's a lot of activity and trespassing on that site. When we actually personally went in the building, there was people living in there that obviously shouldn't be in there. So from the start of this project 2 years ago, we've helped with trying to keep people off the property and trying to keep that a safe area. Since then, and have demolished that building, we've worked with one of the neighborhood members. There has been 2 homeless sites over the past few months that we've worked with TPD and getting them off the site, cleaning it up, and making sure that that site adjacent to them is a safe community. We've responded to every reaction with that neighbor and TPD since then. So some of the outreach stuff that I've done and my team has done, that Rory and Carrie and Robin have done, is we've met with them for the official neighborhood meeting. We've had coffee meetings. We've had meetings for lunch. We've had direct coordination with the ward office and the neighborhood. And then since then have specifically asked for one community member from Camino Santiago to be a daily, weekly, monthly contact for me, with anything that happens on the site or updates from KB. He is not here today, but I did talk to him earlier this afternoon, and believes that there is some support in the neighborhood, but dragging out people to deny this appeal that our supporters from the neighborhood would be tough because you're kind of dividing the neighborhood. And we don't want to do that. It's not something that KB thinks would be a good thing. So given that, working with this neighborhood group over the last almost year and a half, here are the things that we were able to, and working with our corporate team, working with our operations team to address their concerns. So one of them is the single story versus two-story development. When we first came on board, we said we were doing two-story across the board. Well, after deliberation for many months with my team, we came up with 2 single-story plans that we're introducing to the Tucson community. This is the first time that we will see this in the product that we're using. And they're 2-bed, 1-bath structures. Those structures, there's a few of the, and I'll back up, the grading of the property and the way that the engineer graded the site to make it work was that we lowered the site in many areas, except for a few areas where the homes along the perimeter still are a little bit higher. So if it would be a 2-story, then it would create more of a view shed impact. So we did limit 4 of those lots around the perimeter to 1-story. KB is a design or build to order builder. So when you come to our sales offices in each community, you basically can pick your lot, you can pick your elevation, you can pick your square footage of your home, you can pick everything in the interior, including the floors, the cabinets, the tiles, everything. So whoever wants to come in there and buy a single story, they can. There's 4 lots where they have to be single story. That's one thing that I think was really cool that we brought to this project based on their concerns. The other architectural concerns, she was talking about the brick and slump block and architectural consideration for the neighborhood. So we typically do, and you'll see it on the National Home Builders, it's like a stone veneer on the front. Well, we created an option to do a brick veneer on the front to simulate with the neighborhood a little bit more. Also, the walls that we're putting in, we've upgraded them to a slump block wall on the perimeters of the lots. And then again, it's the Southwest color palette. The architectural variation plan forces us to have some varying roof lines and a variety of homes. It's not just the same home adjacent to each other. The other thing, Shannon had a slide that showed that we weren't revegetating the site and we weren't using native plants, and that is completely not true. There were 37 trees that we were able to keep in place that are still on the site today. And for every tree that we remove from site, we have to put it back on site. So essentially, with the native plant preservation ordinance, you have to mitigate, you have to transplant your plants. You essentially have to put so many plants back on the site that it'll be nicely vegetated, like Rory was saying in the end. The buffers are unique in this situation. We border 2 roads and the neighborhood to the north. The neighborhood to the north has a nice alley of a 20 to 40-foot setback. Along St. Mary's, there's a wash corridor that has the existing vegetation. And along Camino Santiago, there's a very nice buffer there that we're able to keep some vegetation. And we're going to be putting in an asphalt pedestrian path there. We're completing the sidewalks all the way around the site to make it ADA accessible. And during our neighborhood meetings, we heard concerns, well, we go through that site to get to Tumamoc. And I'm like, yeah, I see your concern. We're going to have connections. You'll just have to walk a little further. But instead, we said, yeah, sure, we'll provide an opening through the center of the site so you can go straight down to that traffic light and go to Timumac. ADA accessibility. There's also another trail on the northern end of the site that follows the area plan that the natural gas line will become a pedestrian trail in accordance with that. No balconies are allowed on any of the homes. And yeah, like in conclusion, I think that we've done our best to work with the community. They have my phone number on a daily basis. They have my email on a daily basis. All of our development managers have responded to concerns, and our contractor is one of the best contractors in Tucson. So we've got a good team. And we feel that this provides a great infill project that needed for the city and along this corridor. So I'm free for any questions that you have.
Any questions?
I have one question. Were there any conversations about in your meetings with some of the residents? Was there any conversation that the residents or concerns that the residents had that you just weren't able to maybe not meet, but help with or make better? Were there any big items that were discussed that you just weren't able to work with?
I think Rory spoke to it nicely about the architecture. We, build energy efficient homes, and that is required by code. So the building code really wouldn't allow us to go back and build 1970s with their building materials and such. So that was a hard one. So I did what I thought outside of the box and tried to do what I could by creating some single stories and putting some features in there to match the neighborhood. The other one that I've talked with the neighborhood president and has asked me maybe to work with him in the future about Camino Santiago and the traffic along there, and possibly doing a neighborhood grant to maybe do a speed hump where appropriate, something like that, because the road does have some elevation and there could be some visibility issues. So that I've told him that I'm here throughout the project and would like to work with him on that if he's interested.
Any other questions?
Yes, I have a
Okay.
question. I have a question. It's Dr. Bowles. Can you walk us through what efforts were made to gather community input and how frequently that outreach occurred and what specific concerns were raised outside of the architectural that were addressed or not addressed?
Yes, I can walk you through that. So I think our first neighborhood meeting is where we had the most attendance, and then it dwindled down, and that was at the end of 2024. It dwindled down to a certain group of people that we would also have the ward office aide in attendance with us to talk through issues. And we met on several occasions, and there was a lot of emailing back and forth, but is it specifically you want me to talk about something I couldn't address?
Well, the gentleman before you had mentioned that you would come up and talk about the concerns and the outreach that you made with the community to hear their concerns and address their concerns. And I just wanted clarification on his point that he made earlier.
Okay. Yeah, other than the architecture, they were concerned about the vegetation, so we talked about that. We talked about how there's buffers along the entirety of the site with vegetation that will help with the transition from their neighborhood or the street to the subject property. they talked about open space, natural undisturbed open space, and there's, there's a few areas of the site that are labeled as open space, including the wash area, and there's an area along Camino Santiago that remains as open space, and the plants remain there along where we'll be putting a asphalt path for pedestrian access along Camino Santiago. We did, like I said, we did minimize the building heights and allowed for single stories, and then restricted some lots. But it basically was had to do with pedestrian connectivity, which I think we addressed. Do you have anything to add?
Yeah, just one thing to add is prior to the neighborhood meeting, and again, an FLD requires a neighborhood meeting, but remember, it's an as of right project, right? We're not, there was no asking for a rezoning here. This is we're developing under the existing zoning, but with an FLD, you have to do a neighborhood meeting. You all had a couple of meetings prior to that neighborhood meeting with the
Yes.
neighborhood leadership. And then you were kind of in constant contact with that neighborhood leadership sort of throughout, I mean, even until now.
Yeah,
So,
and we do that on all our communities. It's not just Tumamoc, it's being part of the community and a good neighbor and communicating with each other so that we could create a nice network for safety reasons, for trespassing reasons, and all of that.
Thank you for the clarification from both of you. I appreciate it.
Thank you.
Any more questions? Okay, I will open the floor to a rebuttal from. Yes. Sorry, I didn't see anybody jump up when I said, is there any more? All right, anybody else wishing to speak in opposition?
Kind of throw me when you say opposition. I understand it's an appeal. My name is William Carroll, 8830 North Camino de la Tierra. I'm not here to specifically speak on behalf of KB, but I'm here to speak specifically on behalf of the FLD. I've worked in communities all over the state, heavily in southern Arizona, worked with all the municipalities in Pima County, and general plans, comp plans, neighborhood plans, area plans, they have always been treated as a guide. This indicates what we are hoping to see in this area, but for the very reason that they don't want to get into the specifics to say this project must be developed at 2 residences per acre or must have lot sizes of such and such. That's why we have other codes and policies. And so I agree with Rory's comment that we have the guidelines that we're supposed to be able to meet. We're supposed to be able to meet the majority of the guidelines, but we can't meet every guideline. But the FLD is an extremely important tool for development. Every municipality in Pima County says we need housing, we need housing, we need housing. And the FLD really is an opportunity to provide more open space that helps the surrounding neighborhood while still being able to develop at a reasonable density. Infill is really important specifically to a project like what KB is trying to bring forward, which is not high end, but is a relatively affordable product. And without tools like the FLD, it's a real struggle to be able to bring those projects forward and still create additional buffers around the community. I'm actually working on an FLD project right now, so I understand the process. The appellant tried to draw the comparison that the FLD is really a cluster project. And while cluster projects fit inside of an FLD, to me, a cluster project is I'm putting all the homes over here and I'm leaving all this open space over here. And that's not necessarily how the FLD works. Sometimes the open spaces surrounding the property, sometimes it's distributed within the property, but it is an opportunity to have some smaller units, but still provide more open space and be able to meet larger buffers for the community overall. And so I find it, I would hate to see us lose the tool of being able to have an FLD, which really is a great compromise to promote housing and still have a quality product within the Tucson. Thank you.
Any questions for him? Okay, none. Thank you. All right. Anyone else wishing? Okay, one more.
Good afternoon, Mr. Chair, members. My name is David Godleski, Southern Arizona Home Builders Association, 2840 North Country Club, Tucson. I think the previous speaker did an excellent job about articulating the importance of the flexible lot development. He mentioned how it's really just essential for builders to be able to meet the growing housing needs of our community, particularly infill projects. I went back before I came down here to a study that was commissioned by the city from an organization called Eco Northwest in 2024. And that study indicated that Tucson needs over 35,000 housing units in the next 10 years. Nearly 12,000 of those would be considered market rate homes. Last year, based on the numbers that we have, Tucson permitted only 342 single-family market rate homes. So builders, in addition to these tools like the flexible lot development ordinance, they need the predictability and certainty in development review and approval process. And we would be concerned that this project would be a case study in uncertainty and could deter future development. Builders that I've talked to are monitoring this case closely when decisions like the ones you have before you help make an impact on whether builders do business in the city or look to build their communities in other locations. So we'd certainly think that the outcome could potentially be a setback for housing inventory and affordability that we need as a community. And so I'd ask you to support the FLD process, uphold the zoning administrator's determination, and deny the appeal. Thank you.
Thank you. Anyone else? No.
Good afternoon. My name is Corey Thompson, 3945 East Fort Lowell. I'm here to speak in support of the flexible lot development process and to respectively ask the board to uphold the zoning administrator's determination. I'm the engineer that has designed this project. I've designed many FLD projects in this city. And over the months, this took many months to design and develop. We worked really closely with staff. We talked a lot about the zoning, FLD specific code listed items. We worked closely with them. We identified a number of issues with applying the open space, the flexible lot, the functional open space requirements. We had a number of meetings talking about drainage, landscape, native plant preservation, transportation. And we gathered all that information. We put it all into that development plan and went through three reviews, and it was approved in September of 25. I think we put together a very effective FLD project. As Kelly has pointed out, it's very popular. There's a lot of people that want to move there. It's infill. So also just kind of follow along with Rory and Kelly. Really at the core, this appeal is not about a violation of the zoning code, nor is it about whether the project is allowed. Instead, it revisits the question that has already been addressed by the board in the past. Whether adopted city planning policies are regulatory documents requiring strict compliance, or whether they serve as guidance documents requiring general conformity. As the zoning administrator correctly determined, and as the board affirmed in the 2019 case, Arizona law is clear. Planning policies are not regulatory unless expressly adopted as such. And flexible lot developments are evaluated based on general conformity, not strict or literal compliance with those policies. The determination being appealed today applies that same long-standing legal standard. Nothing in this case presents new facts, new law, or new interpretation that would justify a different outcome. More broadly, this appeal puts at risk something very important to the city of Tucson, the ability to develop compatible, code-compliant infill housing. FLDs are one of the city's most effective tools for encouraging infill rather than sprawl, using existing infrastructure efficiently and allowing flexibility in site design while maintaining overall density limits and neighborhood compatibility. The Enclaves at Tumamoc project exemplifies this intent. It proposes the residential densities that fall within the plan low to medium density range, provides appropriate transitions between zoning districts, and demonstrates general consistency with adopted planning policies, all while fully complying with the zoning code. Allowing policy documents to be enforced as if they were regulations would fundamentally change how infill development is reviewed in Tucson. It would create uncertainty for homeowners, developers, and the city itself, and would undermine tools like FLDs that the city has intentionally adopted to support smart growth and housing opportunities within existing neighborhoods. The zoning administrator followed the correct legal standard, applied it consistently with prior determinations, and researched the correct conclusion, reached the correct conclusion. For these reasons, we respectfully ask the board to uphold the zoning administrator's determination, deny the appeal, and reaffirm the city's support for the FLD process and responsible infill development within Tucson. Thank you.
Are there any questions? Okay, no, thank you very much.
Sure.
Now, is there anyone else wishing to speak in opposition? Okay, now you may.
Hopefully this will be short.
I hope.
I know it's been a while. So first thing I want to clarify, KB Homes has been very responsive to us. Kelly especially has always been available for email correspondence, has been willing to meet with us. I wouldn't say that we believe that our conversations with them have been fruitful in getting any sort of community benefits or like what we really care about, but they have not ignored us. There's nothing, like they've been very, very responsive. There was a question about what are the other things that the community really cared about that were not included. A huge part of the neighborhood meeting, and I don't know if the neighborhood meeting was recorded. Huge part of the neighborhood meeting, part of our conversations before the grading happened, was preservation of some of the very mature trees that were on site. So there were some 30+ foot tall eucalyptus trees, some 60-year-old mesquite trees, all of that. We requested, hey, can we develop around those trees, right? There's language in our general plan and in the FLD and in the area plan stating that we want to maximize preservation of vegetation. And we were told they can't do that. They had to grade the whole thing. So there was a lot of mature vegetation that would have actually aided the development, right? You can sell a house for a lot more if it's got a 60-year-old mesquite tree on it. It would have made us feel like they were doing more to blend in with the community. It would have looked better from the top of Tumamoc Hill, all of these things, and we weren't able to get that. We also requested single-story homes just along the perimeter. We acknowledge, like we would love the whole thing to be single story. The Tumamoc area plan implies that if you're going to be developing on sub-area 15, that it be single story. It doesn't say it explicitly. It says if office buildings are going to be put there, they should be single story. So it doesn't state that for residential. But we would love the whole thing, but we've asked, can you just enforce that the whole perimeter be single story? So that way there's at least like this buffer. And that is actually the design guidelines manual, which the city has adopted, which is part of the 2013 general plan. It's interesting because I wanted to bring it up, but I thought, oh, it's 2026. It's not listed in plan Plan Tucson 2025. So I would have gone with the plan that they were held accountable to, but it all states that if there's a 1-story development and a 2-story development, you should put single stories along the perimeter to ensure a more, gradual transition between there. We were told that they couldn't do that. Aside from those 4, and interestingly, a few months ago, my neighborhood association president sent an email to me and said, hey, KB Homes reached out to me, and they said that they will offer single-story homes if you don't appeal the architecture variation plan. And they'll put 4 in front of your house, Shanna. The 4 that they're promising are not in front of my house, unfortunately. But then it's just kind of, it shows bad faith to the community that it wasn't done because we asked for it necessarily. It was done because it helps to expedite the process and it prevents us from potentially appealing. The brick is an option, absolutely. They've shown the architecture variation plan. There is a brick option. I don't know if it's available on the 1-story and the 2-story, so I'm not going to speak to it, but I would say that it's a cost upper. And all of us in the neighborhood have paid a premium for our homes because they are built out of brick and because they are mid-century. So we had the expectation that homes that are being built in this area would have the same look and feel to us, right? People who want to live in the Tumamook area, who wants to live in these mid-century neighborhoods, surrounded by the desert, right? 5 minutes to the Tucson Mountain Park, where hiking trails, 10-minute walk to Tumamook, if not less. That there's expectations that we maintain